Okay. I have a lot of clients who ask the question about orders from the court. And so we are going to kind of break down what an order is and why they are so important in your family law case. Okay, I have a redacted copy of an order. This is what an order will look like. It says order. Okay, it could say order on temporary hearing, or order on motion for fees, or order on anything. This particular one is just an order of referral to mediation. Very basic, something that a judge does in a lot of cases before you can go to a final hearing. And this particular order of referral to mediation just says, before you can come to court, you have to go to mediation. Okay, it's very simple, but it outlines what you have to do, and it gives you the number of things that you have to do, or your attorney or the other side. It might be long, it might be short, but at the end, the most important thing is that it is signed by a judge, okay? This one is signed by Judge Miller here in Escambia County. It's signed by a judge. It'll have copies to your attorney at the bottom. The most important thing you need to know about an order is it is a requirement. So in your brain, think of order equals requirement. You are required to comply with the provisions of the order. Now, you're gonna say, but Autumn, what if I don't like what the judge says? Or what if that isn't true? What if what the judge said isn't really what happened? So judges are required to make findings of fact and apply the law. So it's the judge's job as the trier of fact to say, these are the things I heard, and this is what I determine are the facts of this case. And then they make a ruling based on those facts. Okay, if they make a finding of fact that is incorrect, we have remedies for that. But it doesn't mean that you get to just ignore your order. Let's say this order is in your family law case and it says you are to pay the other side $1 million in 60 days. Okay? That is the finding of the court. That is the order of the court. Could you pay $1 million? I have no idea. I have no idea what your particular circumstances are, but let's just say that's what it says and you do not want to pay it. You can be in contempt of court if you do not do what the order says. Orders are not, think of a little circle with a line through it, are not optional. Orders are not optional. So if you have a problem with something that the order says, or you don't think it was fair or just, then that's something that we can talk about as your lawyer. But you have to comply with whatever the court says to do. You comply first, we seek remedies after, you ask questions after, but it does not look good when you have orders and you don't follow them. Judges are not inclined to back off of their orders once they're not being followed. You must have respect for the fact that your judge is the one who's assigned to your case and gets to make these decisions. And the way that you can make sure that the judge knows that you respect his or her orders is to follow them, okay? So if you have a document or you receive something from our office that says order, that means you have to do something, okay? If you're confused about what you have to do, call me, ask us. Anyone in our office can help you. Ask the question. If you don't like it, sometimes it happens. Sometimes we can do something about it. Sometimes it was wrong. Sometimes there was a mistake. So, but not complying with an order is not optional. All right.